Make sure you put your email address next to it. Pretty sure I've got you guys' email address though. I don't want to say things that annoys me at all. It might. Looks like we got a couple minutes. Maybe for being Dole. I don't know what his. I know he's in trial uptown. So.
Oh, is he?
Oh, he's in trial?
Yeah.
Where is he?
I want to say. I mean, he said Riverside.
Okay.
So.
Might be a little bit late then.
It might be. Yeah.
It was usually late when we had Yoder our first year.
It's a good reason to be a little late. I mean,
Yeah. No other choice in that matter.
yeah. You get out when the judge lets you out.
I gotta tell you, I have, been doing this a long time. I have never seen anybody go to trial as much as King Dolan. I mean, he seems to always be in trial. And,
It is like so.
and I wouldn't even say that because he's one of the easiest guys to. Me and him never had a trial together. we resolved everything we ever had together. I think it's just, he's probably like the only one on the conference panel that they can give these serious cases to, and so I think he gets a lot of it. And he just seems to always be in front. So why don't we start? Go ahead and get started. Let's go through the syllabus, and I'm sure you guys already went through it, and you're like, this makes absolutely no sense.
Not just made me cry a little.
And it's true. It should make no sense because somewhat we're going to be doing this on the fly. Okay. So as we go through it, we'll talk about how things expect there to be modifications. Okay, you got Dean Dolan's contact information. You got my contact information there. Right? Really, when we talk to, there it is. When we talk about the ultimate goals of our of course, right, it's to give you practical, hands-on trial experience in this non-trial environment and give you an opportunity to practice the skills that will be needed with people here to offer feedback and the like. So ultimately that's the goal, is that when you stand up and you give your first opening statement, you will have given an opening statement at least in here. Okay, you will have given more than one opening statement during the course of the class. So we want to go through skills, the theories, the art, that is behind trial advocacy, and the book does a good job of that, laying out some of that for us. But ultimately, I mean, you can know everything in this book inside and out, and you can stand up in front of a jury and not be able to deliver. Right? There's two different parts to it. There's the ability to deliver, and it's hard to explain how you get good at it other than doing it. Right? You get experience through your experience, you gain confidence through your confidence, you get pretty good at it. Right? When you look at trial lawyers who just don't look comfortable up there, they're nervous, they don't, they may babble, they may stutter, they may lose their train of thought. And that's all an aspect of the nerves that they have going into it. So, I know I was nervous my first trial, and I kind of stayed nervous my first trial. Now, whenever I was in trial, I'm always nervous the very first time I stand up and address the jury, and it quickly fades, right? You just get comfortable that I've done this 100 times, and you just get comfortable with that. The nerves fade quickly. Okay, so ultimately, that's our goal here, is to give you an opportunity to practice some of these skills after trying to give you an understanding of, what makes a good opening, a good direct, a good cross, a good close, so on and so forth. Okay, attendance and tardiness. Well, we got to put something here, right? There's only 3 of you. It's kind of obvious if you miss. It's kind of obvious if one of us misses a professor. And just so you know, this is not an original syllabus. This is a syllabus that was developed by Judge Chapman and Justice Miller when they taught this class, and Randy Dole decided, well, we're just not gonna, we don't necessarily need to mess with it. They did a good job, but we're gonna handle things the way we handle things. Okay, so of course we want you to be here in class on time, right, ready to perform. Right? Of course we got the sign-in sheet. You guys have been here, it's your 4th year. You know how all this works.
Hello, gentlemen.
Hello.
Sorry, it's a long drive back from Rivers.
We're just going through the syllabus.
Good.
Okay.
Now, let me go get mine.
Oh.
Because I'm gonna just go keep going. I'll just go.
Here's where we have some leeway. Right here's mandatory class assignments. Okay. We would like for you to write out your opening statements. It says direct and cross. Both John and I both are a firm believer that if you're writing out directs and cross, you're not going to be good at it. Right? Maybe you have an outline, maybe you have points that you want to make, you have a flow that's in your mind, and you jot that down. But as far as writing out every question, we're both anti writing out questions. So, but we do expect you to have put some thought into it, not just to show up and say, I never wrote anything down, and wing it and expect to be successful. So we do want you to write out certain things, and as it comes, we'll tell you, hey, opening statement, we'd like you to put some thought into your opening statement. We'd like you to write it down. And you'll give us drafts, we'll look at them, we'll review them, we'll give them back to you, and the like. We ask that you bring copies of class of whatever you've written out, even if they are just an outline of how you're going to go about your direct or your cross of the areas you intend to cover and the points you intend to make. Okay? And then we'll get feedback, not only to your written, but then your actual performance that you give, and then we want you to then incorporate the feedback that we've given you into your next performances to demonstrate that you actually listened and you've learned and you've grown. That being said, some of the stuff we take with a grain of salt. Okay, I was told very early on to get my hands out of my pocket. And I've probably been told 1,000 times. You know, you stand up there and you got your hands in your pocket. I always have one hand in my pocket. I'm talking, that's where I'm comfortable at. I've been successful keeping a hand in my pocket. And I'm comfortable keeping a hand in my pocket. So some of these things, despite all the experts telling you this is what you got to do, not everything is make or break. Okay, some of the stuff you can kind of just take it for what it's worth and incorporate that in. When we get to trial, right, you will be required to construct a trial notebook, and you will have a final trial. Our plan is, and I think it worked out fairly well last year, is we had a trial using a mock trial team. And we were the attorneys, and the mock trial kids played their part. They were the bailiff, they were the clerk, they were the witnesses that we examined.
And the jury.
And the
leftovers.
So, you know, it works out well that way. So that's going to be our goal. You do not have that case yet. We don't have that case yet. But
I think we get it at the end of September, either that very close to our 27th date or the week after. And then we'll have them come down and maybe also help you in some of your other cases as far as having experience for them, because they'll be getting ready for mock trial. So I think it'll be great.
And it's good practice for them as well.
Cross-pollination there.
And in a lot of ways, it kind of gives you some real life practice, because, you know, you're going to come across witnesses that you're going to put up on the stand, and you think they're going to say one thing, and they don't. But wait a second, didn't you say this, you know, under oath at a prior proceeding? Nope. Well, you'll learn how to deal with that before we get that far. But in some respects, it gives you good practice. Okay, the reading assignments, you see the reading assignments are set for 5 weeks. You know, this being week 1. Grading, that's what everybody wants to know about grading, right? We talk about, you see it broken down there. You get 20% for your written assignments, including your trial notebook. Then you get 10% for each of the things you're going to demonstrate, and the bulk of your grade, 40%, right, is going to be your trial at the end of the year. Okay, and it's full trial. We suit up, you know, we do the whole shebang. We don't come in, you know, casual clothes, and we suit up and we put on the whole trial over there. And His Honor puts on a robe. It's
as close as I'll ever come to that.
Yeah. So, and one of the things that, you know, I want to talk about too is, you see down at the bottom, right? We expect you to provide critiques for each other. Okay. Any of you, maybe, I don't know, maybe some of you have, but any of you could be a juror. Okay. And the feedback that you have for each other is just as important as the feedback that you'll get from us or any other instructor or any guest speakers that we bring in. Okay? Just as valuable. Because ultimately, I can impress the hell out of a whole bunch of lawyers, but if 12 jurors think I'm just acting like a pompous ass, then I'm not going anywhere. Right? But the lawyers are, oh wow, that guy looked really good. So, you know, the critiques that you give each other, be kind, but be truthful, be honest. You know, you don't have to be rude and disrespectful, but if something that somebody did just, I didn't really like the way that came across, you got to share it with each other so you know that going forward.
Yeah, Victor, be nice.
Okay. As you see here, week one's pretty straightforward. You got the reading assignment. We're going to talk about the trial overview today. You know what's going on next week. Well, next week you're supposed to have written your first draft of your opening statement. Like, okay, well, what's my opening statement? Well, that's kind of where week 3 comes in, and that's what we'll talk about. Okay. There's only 3 of you. So what we need to decide is what type of cases you guys are interested in working on, and then what type of, we'll break these numbers down. For example, in week 3, you may have, State v. McNamara. If you want State v. McNamara, and Will, you're going to give the opening for the defense. You're going to give the opening for the defense. Victor, you're giving the opening for the plaintiff and Kent v. Bonds, right? And Will give the defense, right? We're going to mix it up because you're going to get more experience doing more things. So what I think would be a good idea is if you guys go through the case book, kind of give us an idea of what it is that you want to, what type of cases you'd like to work on, knowing that these aren't going to be your trial cases, right? But these are going to be the cases in the case book that you're going to be developing your opening statement, you're going to be developing your direct examination, your cross-examinations. Those are going to come from the cases that are in front of you. So we need to pick those, and then we need to decide how we're going to go about who wants to do what. Of course, what we would like to see is each of you to take a side in a case, not, well, I only do criminal, and I only do prosecution, well, I only do civil, and I only do defense, and I only, well, I want a family law case, right? We'd like to see you mix it up and get out of your comfort zone and do a criminal and do a civil and do a defense, and so we'll need to at some point sort through that, and that's where the syllabus will be modified. Okay, and hopefully once we pick a case or cases, preferably 2 different types of cases, then we'll kind of stick with those through your performance just because there's a familiarity with it. Okay, you've given an opening on this, and Kent v. Bond rental, and that's the guy with the jackhammer and
The bathtub,
and
lost cabin's foot.
Okay, so
It's
you'll become more familiar with the case file as you go through it, and your directs and your crosses will be better for it than mixing up and picking a new case every time.
Pete, did you mention our guests on September 27th?
I have not.
I just went around and told everybody else, first hour and a half on September 27th, everybody's going to be in the big court.
Now, we had planned to kind of hit you off with a bang. Next week, bring some experienced trial attorneys in there to kind of talk to you about the overview of trials. And then they both promptly said, well, kids and open house and back to school night, and can we do the 27th? So we got pushed off. But you're going to get to hear from one of my all-time favorites. Judge Sterling is going to come, and I just think he's fantastic in trial.
Excellent.
And he's got a lot of insight. And now he's got insight from the bench where he can tell you, here's what I see lawyers do every day that's just bad. Don't do it. And we're going to reach out to other people as well and try to bring other guests in here. Maybe there'll be guests to share their thoughts. Maybe there'll be guests to observe you and offer feedback. But we're going to have to get confirmation. I've already reached out to a few, get confirmations as to which states they're available. Okay, so those will be fit in here, but as it stands right now, we know the 27th is now set to have 2 guest speakers, and of course 20th, which is week 3, is supposed to be your opening statements. I'm not here on the 20th, so that'll be a lot of fun.
We might do a little rearranging. I mean, the good thing is with this size of a group, we can be very flexible. Let me ask you guys a question though. How many of you have actually been in a trial?
You mean seen one?
Sat through a trial?
Yeah.
You have? Have you sat at the front table? I mean, have you sat?
No, I always
Council table?
No.
Okay. I mean, at least you've seen a trial. Have you been through a trial from the beginning to the end, Victor? Although you've worked on civil stuff, but you've been and watched trials. And obviously you have your experience at the PD plus working with Diane, so you've got lots of.
Well, just the PD saws. I would try to sit through an opening across or a closing of every trial that went through there. With the PD's had, every single one.
Well, look, there's nothing, you can talk about this, till you're blue in the face. You gotta be in one to really start getting it. I don't want to jump ahead, but I just, eventually I want to make some comments to you guys about what the big picture is on how trials work. And hopefully this starts to bring together all the stuff we've been doing for the last 4 years. I've had the experience, I must have had 5 or 6 students sit through some trials, and everyone says, oh, the evidence code. Oh, yeah.
It is important.
Evidence class, is an important class, but you just don't see it come to life until you get into trial and you see it happen. And there's just nothing like it. So it's just ridiculous that I'm driving back and forth to Riverside now in a trial. I'm going, why am I doing this? But I love it. I love being in trial. So, you can't ask for a better professor than Pete. And Pete is now becoming a civil lawyer. So we're going to have some examples beyond criminal law here, which is a wonderful thing. And you work
a civil trial.
You work for a fantastic lawyer. You work for a great law firm, and Victor works for the law library. You can't beat that. I mean, that's all good stuff. So, you guys are getting to the point where you can exchange information with us. You don't have to just be on the receiving end for what you have. And Pete and I've done this several times, and I just think this is probably one of the coolest classes because I'm not too worried about what you're writing an essay or anything else. I just want to see, can you get to the point where you can actually do this? This is a very rarefied atmosphere. Less than 1 or 2% of lawyers ever even get into the courtroom and have a trial. So I think it's the greatest thing that we do as lawyers, but not everybody agrees with me. You can make more money not going to trial. I can tell you that, but we're going to have some fun here. And I think at the end, hopefully you'll be exposed to a lot of people who are heavyweights, at least in our neighborhood out here.
And just if I could, not to criticize those that have come before you, but some that have come before you kind of gave this short shrift. This is probably efficacy. I don't necessarily need to put in the time and effort here as I do in my other classes. And I'm a forward, I got serious stuff weighing on my mind. And I think you lose something, right? By not coming prepared, by not reading the materials and putting an effort in, right? This isn't going to be as work intensive as some of your other classes that you've had, but what we do ask, it isn't much, and I think putting in that little extra effort will help. We've seen students try to wing it, and it's shown us like, okay, what are you doing? Did you even read your case? Because it doesn't look like you put much thought into it.
Yeah, I mean, like when you're doing an opening statement, reading it is just not the answer. You could have an outline if you want, but really you need to be able to express what's in the case. So you got to know it. You got to know what are the facts. You got to figure out how you're going to maneuver through the facts in your opening statement, your closing argument, all that.
So just kind of know as you look from like week 1 to the end, expect changes, right? Just know that as you look at like week 3 and week 4 and you see those numbers, in week 5, you see the numbers and you see the assignment, those are subject to change, right? The numbers are you guys. There'll be a 1, a 2, and a 3, and you'll be representing that. And to the extent we need somebody else, we'll throw that in. I was an attorney last year in a trial, and what was funny about that is, I think it was Aaron. I was like, okay, well, you guys what do you guys think? Who do you want to be with? I'm the fourth trial. And Aaron immediately said, I want to be opposite.
Mhm.
I don't care which side of the case you put me on. He said, I don't want you as my teammate. He said, I want to, go.
Nothing personal.
I want to go against you.
Yeah.
And
Smart.
because I didn't take it easy on them. I objected if there was objections, and made them actually do what they were supposed to do. And I think he appreciated it. But just know one of you is going to get me as a teammate, as a trial partner, and I pull my my share of work.
I figured we were just going to do 2 versus 1.
No,
Yeah.
Not gonna happen. But it's good exercise, I'm telling you.
So we'll go through these and just expect the weeks to be modified and filled in as we go through them. The readings for the most part are going to be consistent. So as we finish, tonight, you'll have a good idea of what we expect to do next week. Okay, and then what we expect to do the week after that. And our schedule, to some extent, is going to be fluid. If we got a guest speaker that can come in, but they can't be here till 7, okay, then we'll make it work. We'll do something, which maybe you guys doing something between 6 and 7, and bring them in and let them speak. But ultimately, what we're looking for is an effort on your part for preparation, in your actual performance, and in your critiques of each other. We want to see that you're paying attention and actually putting into practice, the skills that we're talking about, that the book is sharing with you, and that we're sharing with you from our practical experience and our war stories. Okay? You guys will just instinctively know what works and what doesn't, right? Primarily when you watch somebody else. Okay, when you're doing it, you might think, oh, this is a great argument, and the juror's eyes are glazing over, and then you see somebody else argue that exact same point of law in a different way. It's like, I didn't even think about that. That's great. I'm going to use that. I taught voir dire for the DA's office for the last 5 DA academies before I left, and it's not even my voir dire. Right? I got it from somebody else. I saw somebody else do it. That's fantastic. And I use that same voir dire in every case going forward. So watching other people, you'll know that that's not working for me, or that is. And I remember watching Dean Dolan's close on the Boys and Girls Club.
Oh yeah, Sparza.
Yeah, I remember watching his close. I didn't see the prosecutor's opening argument or rebuttal argument, but I saw Dean Dolan's close. That was the only portion I could make, and it moved me. And I said, I don't know. And I saw the way the jury was responding to him, and they came down in your favor on that one.
Yeah, we got a hung jury
Yeah.
that first time.
And
Unfortunately, we had a second trial.
but you just knew. You just knew the arguments were there. The jury was responding. I was like, these are pretty compelling arguments right here. I didn't see the trial. I don't know if the evidence came out that way, but clearly the jury had agreed, and I knew walking out of that, having not heard anything else, like, this isn't a good verdict for us.
And Jake Silva was the DA, and Jake Silva's an excellent lawyer too. Really a well prepared, a tangential comment. Younger lawyers tend to get more personal and have more acrimony in court. when you have enough years under your belt, it's more about what are the issues in the case and not about nasty comments and all kinds of stuff that happens in court. Although I must say the civil court's a little more nasty. Maybe it's some of that, you haven't been too many of the nasty letters and stuff in civil that we don't even see in criminal cases most of the time, but that's another story for another day.
Yeah, I've drafted a few letters that have been edited, and they apparently mine were too nice. They were edited to be harsher. Oh, okay. So that's the tone we're taking on this.
Do you guys want to do trial work?
Want to be able to do it.
Okay.
I already family law, so it'd all be judges rather than jurors.
Yeah. Yeah, the interesting thing is just have a passing familiarity with the evidence code, and you'll be better than half the family law lawyers that you ever run into. It's amazing to me how horrible it is to watch people like, "But Your Honor," that's the objection. "But Your Honor, it's important to my case." Well, I just don't find that anywhere in the evidence.
And something along those lines, now that I'm out of government service and I got to actually kind of earn my money now, part of it is, you got to bring clients in. Okay? And I'm assuming you've been to family court.
No, not yet, actually.
Oh, geez.
Okay.
But I just like the idea of the argument.
When you're doing your thing in family law, the audience is filled with all the other cases that are waiting
It's an
for
audition.
their call.
Yeah.
And I, last Friday, I argued a continuance.
Argue to continue.
That's civil law right there.
We're set for
Yeah.
trial, and this guy doesn't show up twice. Like, the attorney just doesn't show up.
I love that.
And it's a day of trial. And finally, the second time, I was like, he doesn't even, I haven't even heard from this guy. I want a bond posted, we're objecting, and I want an order to show cause, sanctions, and the judge, okay, anything else you want, Mr. Nolan? It's giving me everything I want. I walk outside, and two people walked up to me and said, "You're good. Hey, can I get one of your cards?" Well, yes, you can. I never gave a card out as a DA. Rarely. I got boxes of DA cards. But your performance in court can impact not just your client's case, but your ability to build a reputation in the community, and clients will be impressed. Potential clients will be impressed. And now, neither one of those guys have called, but they had my card, and it just felt good for me having somebody actually ask me for my card. Hey, can I get your card?
I like the criminal cases where my guy gets convicted and they say, your guy was guilty, but if I ever needed a lawyer, I'd like to have your card. I go, okay, we're advertising. So what, I think we'll sort of wander through some of this stuff. Do you have any game plan on how we want to do this?
No, I thought I guess it was 2 years ago. I'm still very impressed. 2 years ago, we came to the first night of class, and there was no books. We hadn't got our books. You guys hadn't got your books, and we were just winging it. And we said, okay, let's talk about trial and case developments and openings. And we nailed it. We hit everything that was in the book,
It was in the
plus-
first 50 pages.
plus some,
Yeah.
just our own experience and how to do it. So you'll get a lot of that. And we want to kind of use the book because you see the title of it, right? We're talking about the art and the science of trial advocacy. There is a science to it. There's been a lot of studies done. This is what works. This is what's effective. This is what people naturally respond to. And then there's an art to it. Like, some people are just gifted at being able to do these things. They're gifted orators. They're gifted with their logic and their ability to formulate arguments and do so in a persuasive way. So you got to be able to kind of combine both of them to be good at it. You don't have to do any of that to stand up there and do a trial. Anybody can stand up there and actually go through the motions of doing a trial, and you might even win. And when I did my undergrad, I worked at the Foot Locker. This was late 80s, early 90s. Can you guess what our top selling shoe was back in the late 80s and early 90s?
Jordan?
Air Jordan, right? Top selling shoe. And we used to have this saying, anybody can clerk a Jordan, right? You don't need to do anything for that. Somebody's gonna come in, hey, I want a Jordan and a size 10. Okay? It takes no salesmanship to do that, right? To sell other shoes and to get the customer what they really need, right? It actually takes a little bit of skill, and we work on commission and whatnot. And trials really are no different. Anybody can stand up there and ask questions, and give a sloppy opening and give a vote, and you might even win. Right? The evidence might just fall in your favor that well, but to be good at it and to be consistently good does take some skill, and knowing the art and science theories behind it will help you develop those.
There's a lot of process involved. So you learn the process so that you, when you're in court, are not thinking about where can I find the piece of paper that tells me about what somebody said. And you listen carefully to witnesses and to the court. It's amazing how much you get. And it's also amazing to watch lawyers who don't pay attention to the answer to their question. And then they ask what they just were told in the next question. And I guess maybe, let me just make a couple of comments here. I've told you, you guys have heard this from me before, but I can tell you right now, the number one currency in trial is credibility. If you have credibility, if the jury perceives you to be credible, if the way you put on the case is credible, it's the number one persuasive tool that you have. The second is emotion, and there's always emotion. There's some emotional appeal in almost every case, even in civil cases, believe it or not. And those are the two most important drivers behind decision-making, verdict rendering. And then the least important of all are the facts. Although we spend our entire life thinking the facts are what we're going to put our case on. Now, you can't boot the facts, but having a mastery of the facts is part of building your credibility. Having a mastery of the evidence code, so if the judge rules in your favor most of the time, part of building your credibility. Having a relationship with the judge, so when the judge addresses you because you're prepared and because you know what you're doing, they address you in a wholly different way than if you're a bozo that showed up in court. And that is a huge credibility builder. So when it comes down to it, of course, I'm big on how can you simplify things down to make it understandable. Credibility is by far the driving force in any kind of a verdict that you want to get. And you build credibility by knowing courtroom etiquette, like, I don't know if you looked on page 6, just these basics. You're not wandering around in the middle of the courtroom and you're not, addressing the judge in a way that's not appropriate, and you're not showing up with gum sole shoes, and a wrinkly pair of pants and whatever, stain on your tie. I mean, it's all you would think that's sort of cosmetic, but the truth is everything about you is credibility. From the time you get anywhere near the courthouse until the time you're gone back home, people are watching you. The jurors are watching you in the parking lot. They're watching you in the hallway. All that has to do with credibility. Do people say hello to you and how are you doing? And you appear to be a person who's known in the courthouse always. Very important to your credibility. How the court clerk interfaces with you when the jury's either when the judge's not on the bench but the jury's in, or maybe when the jury's just watching, or maybe there's a big group of jurors because you're just picking a jury. It's so important to recognize all of the things that we do have to do with credibility. And the second thing I will tell you that's the best advice I ever got was start with the end in mind. So you need to have your jury instructions, whether it's criminal or civil. And obviously you need to have your case organized so that you have an idea of what your case is. And then you need to look at the jury instructions and you need to work backwards on how you build your themes and how you develop. Because in the end, when you make your argument to the jury, the judge is either before the argument or after the argument to give the instructions. Your language is mirroring or paraphrasing what's in the instructions. you raise your credibility level and you raise your probability for success massively. Plus, if you don't know what you're going to argue based on what the jury instructions are before you start messing around in court, you are asking questions that don't have anything to do. I mean, you see lawyers sometimes, I mean, I'm obviously on the defense side. See a prosecutor go through, lay all this stuff out with a witness, and then the defense lawyer goes up and says, well, you said this, is that right? Yeah. And you just repeat everything that the prosecutor said. And then you wonder why, it doesn't work so well. If you know where you want to go, you don't need to spend 3 hours on a witness to cross-examine. You need to spend whatever time is necessary to get what you want in the argument you're going to make at the end of the case, and then you move on. The other thing is you don't make the argument with the witness. You ask one question less than what you need in order to make the argument. So in the end, when you make the argument, nobody can respond back. At least the witness can respond back. So, you said the guy wore a black shirt, and you know that you have, some evidence that the guy wore a white shirt. You don't say, well, that can't be right because he wore a white shirt. Isn't it true that he wore, you're never going to win a case like that, Just say, I want to make sure you're real clear. The person you saw was dressed in black clothing. Yes, absolutely. When you get to your closing argument, you can say pretty clearly this guy didn't see the guy he thought he saw because this other guy had completely different clothing. And the 3 other witnesses described the clothing. I'm just in the middle of that right now, okay? So it's just important to remember, we are doing what we're doing in direct and cross-examination to have an argument at the end, to fill out the information necessary to make the argument, not just to hear your voice or not just to show that you're smarter than the witness. So remember, there's a point to what we do. There should be a point to what you do in court, not just do it because you think it sounds right or looks good. And there was one other thing I was going to tell you, and what was that? Oh, and I've just learned this over the years, you've got to get your file organized before you start looking at the jury instructions. So we now have a system, we get bait stamps on the bottom of, you know what bait stamps are? So we put something in bait stamp order, and then we put it in alpha order by witness, because that's how you try a case, by witness. And then we cross-reference it. So it takes a little time to do that, but once people are trained to do that, you can have helpers sometimes. And then what you do is you go through it and you just started getting a feel for what the case is all about. And that tells you, you've got a murder case, well, what kind of defense could you have? Well, I have an identification issue, or I have an intent issue, or whatever. And then you go to your instructions and you start getting that stuff put together. And then you say, what is it that we have to have in order to say this is a faulty identification? What do we have to say that this was self-defense or heat of passion? Then you work backwards to what you do with the evidence that you have. So that's why I say it's a process. You have to know how to organize your file process down. You have to get the jury instructions first and work backwards process down. And just those two things will make you a better lawyer than most people you'll ever see in the courthouse, because most people honestly don't have a clue, at least what their final argument is going to be. You see all the time in criminal cases, and I think in civil cases it's different. Lawyers come in and they talk about the jury instructions after they've had the trial with the judge. They did that. Well, what instructions are we going to have? We just had 3 weeks of trial. Now you want to know what instructions you're going to have? I mean, what were you doing in trial for 3 weeks? And it's very common, I would say, more common than not, instructions don't even get discussed until toward the end of trial. I don't know how you do that, but it happens. So this is a process, and part of it, the process is the skill part, and then the art part is managing the trial based on the fact that you have the skills and the process down. And you got to listen. I mean, when you see or hear something in court and you're paying attention, it's amazing what you can do with it. And if you're not paying attention and you miss it, it goes over your head. If you can't do something with it, you're not doing your client a favor. So we are very lucky to have Pete, because he's had literally well over 100, I'm probably 200-300 trials, and I'm probably in the 250 or 300 range now. And I can tell you that every time you do a trial, you should learn something. You should learn what not to do sometimes. And if you want to do trials, now family law, I'm telling you, Go out and try about 10 DUI cases and then go to family law, and you will be killer, because some of the best family law lawyers are people that have practiced criminal law, because they have to know the evidence code. And then when you go into family law, if you insist that the evidence code is followed, now some judges won't do it. You know, some judges just won't. They just are used to everybody bickering and, you know, whining. But the ones that really follow the evidence code, you'll kill people, I mean, in your first few years, if you just have the evidence code down in family law. And civil litigation, I don't know if you ever had a trial. I guess you eventually get to trials. One a year is a big, busy calendar, I think. Maybe
That would
two.
be-
I think I have them all the time.
That
Yeah.
would be a lot, yeah, 1 a year.
Yeah, but I mean, still, you know, it's a rarefied atmosphere, and there's very few people that ever get the luxury of actually spending a week, a month, a year in trial. And I think most lawyers would tell you that you don't make a lot of money while you're in trial. It's probably true. But trials are auditions all the time. What Pete was saying is so true. If you're in trial, people are coming in and watching all the time, people in the hallway. It's amazing how all those people end up potentially becoming clients. So you guys are getting to the edge of, we try to design it so after this semester, the next semester, it's mostly stuff that you're gonna have on the bar anyway. But you should definitely put in the time for this opportunity. And for you guys to teach the witnesses how to be better witnesses and how to be courtroom personnel, it's very useful for you. So I'm not quite sure how we're going to make our way through this, but I can tell you that once you know the etiquette of the courtroom, once you know the process to get a file ready to go to trial, once you follow through on the jury instructions and work backwards to make your arguments, just those 3 things will distinguish you from a lot of people that you see in court.
And it's, when you have that reputation, then it helps you in court. Judges know to rule in your favor because you've got a reputation for knowing what you're talking about. You'd be surprised how many cases may settle that might not otherwise settle because I don't want to go to trial against this guy, you know, this gal. So it's a building process as well. And aside from just the courtroom etiquette, you know, there was a section in chapter 1 that talked about stylistic things, right? Are you adversaries? Are you going in there guns blazing? Are you gladiators going into battle? They're out there, right? Those lawyers are out there that will fight you tooth and nail on everything. They're not winning trials. Okay, if you look just here in the valley, who are the best trial attorneys? They're not the ones that go in fighting about everything. And it kind of blew me away. That was not, well, why do people do it? Right? If that's not successful, if that's not what juries necessarily want to see, why do we keep doing it? Well, you're in private practice and you want business. Defendants want to see it, right? They want to feel like you're fighting for them. You're not giving an inch.
That's what family law is here. Oh, I want a real mean lawyer.
You know, and
They say that all the time.
but are those the ones that are successful? And that, you know, they're just not. You can be an advocate for your side, for your client, for your positions, without being an adversary of your opponent. It's okay to agree about things, and when there's something to fight about, you fight about it in a professional way. You make your arguments, they make their arguments, the judge gets to do what the judge gets paid to do, which is make a decision, and you move on. And it's not the end of the world if the court rules against you, you know?
Half the time the jurors don't know, by the way. When the judge says sustained or overruled, they don't know. So he says sustained, you say, thank you, Your Honor.
Yeah, and you smile. He's the master of that. Thank you, and he smiles. And I don't know, a couple times I thought the judge rolled in his favor. You did say, hey, right? those things go a long way, right? Aside from credibility, right, I think one of the things that helps get you to credibility is likability. I remember early on I was told, when you're picking a jury, try to pick people that you would like, that you would want to go have a beer with, that you would want to have a conversation with. Because if you're feeling that way about them, likely they're feeling the same way about you. And if they like you, then they're more inclined to start feeling, that you're more credible if you maintain that. And you do that by showing respect to not just to court, but to counsel. Right? We're taught very early on in DA school, right? Dehumanize the defendant, right? That's not Mr. Smith, that's the defendant. I never did that. I always called the defendant by their last name. And I got feedback from jurors afterwards over the years that said, we appreciated that you did that. It's just a gimmick. Right? It's a gimmick to say, the defendant. The jury knows what you're trying to do, and that gimmicky stuff doesn't necessarily get you anywhere. So being able to carry yourself in a way that is consistently professional and deferential to the court and to the process and respectful of the other side, the jury sees that, and I think that moves them to wanting to listen to what you have to say. Okay? And if it's not sincere, they pick up on that insincerity as well. All this politeness is contrived. That's not how you are. We can tell you're just trying to sell us this. So it's gotta be sincere in how you do it. And then know when to fight. It's okay to fight. Sometimes a jury is looking for you to fight. I had one particular case where I gave my closing argument. This was like a 3-week trial. We had been through trial, we gave our closing argument, defense went up there, and to me, just gave one of the most unprofessional, things ever, and attacked my cop, and I sure hope none of my loved ones get killed. You're the investigator that comes. Just really was over the top in their condescension, and I came out guns a-blazing. And I directed much of my rebuttal at my opposing counsel. Didn't call it my opposing counsel. I called the defendant, but they knew exactly who I was talking to. And the juror foreperson came up to me after and said, you needed that, right? He said, it didn't look like you believed in your own case. It wasn't until we saw that fire from you in, your rebuttal that kind of put us over the top. So there is a place, and there's a time, and there's moments. I don't want to say in every trial, but in some trials, there are those moments where that righteous indignation comes out and it's appropriate. And you're just going to have to kind of feel when that is. And it can't be every time the opposing counsel objects. And it can't be every time the judge rules against you. It's got to be appropriate and rare.
My friend Terry Giles, the guy that we named the trial courtroom after, I was in so many trials, he was my debate partner in college. And I don't know where he learned it, but he said in almost every case, there's one witness that screws your side of the case up. There's one witness that's just going to come and just eat your lunch. He said, so always you want to be real cool, real confident, real well-behaved. And then if you're ever going to lose it just a little bit, save it for that witness. And then just sort of, begin slowly, but eventually come to the point where you actually almost have to catch yourself and be a little bit too aggressive. And then you sort of calm down. And the communication theory is, this is a good person. This is an honest and decent person. Back to credibility again. Boy, if this person is upset with this witness, that witness must not be telling the truth. And it's just one of the, there's all these bits and pieces of stuff that you pick up over time. It's amazing how that works. But you can't yell at every witness or get after every one of them or try and act like they're all lying. Just pick the one that really messes up your case, because there's always at least one. And that technique I've used it myself, and I've seen it used over and over again. And I don't even know if some people know that they're doing it, but juries definitely pick up on what's going on, what's the atmosphere going on in the courtroom. And Pete's right. I mean, let's face it, that was just an example of an emotional appeal that's more important than the facts. I'm telling you, credibility and emotion, if you have, it always amazes me. There's some lawyers that seem to always do well, and you wonder, how the hell, that guy didn't even know what happened in this case. And it's almost always because they know how to work with a jury, to work the credibility and the emotional angle. And if you really actually read your file and had facts, it's even better. But there's a lot of people that don't spend a lot of time on the facts. Just weird, because you expect after all the work we do in law school that it would be the facts that control. And of course, that's what we say in all the jury instructions. It's not what the jurors decide on at all. Very strange.
Why don't we just take a look? Because I agree with you, Noel. I think credibility is probably the biggest thing that you can do in a trial, right? There's a whole section on it there on page, it starts on 16. If the jury trusts you, when you stand up and you tell them, this is what I want you to do, they will do it. If they don't trust you, they're not going to do it. Or if they don't trust you and they don't trust the other side a little bit more, they might do what you want, but grudgingly, because I gotta vote one way. But yeah, there's just something about leading them to where you want them to be, and if they trust you, and it's attorneys are part of it, but you'll see as we get into it, expert witnesses are the same way. If you got a good expert witness that is likable and credible and believable, the jurors love that. And it doesn't matter how right the other side's expert is, if they're cold, or they're scientific, or they're uncaring and impersonal and condescending, the jury just doesn't like them. And they go with the side of the expert that they like. And science be damned, right? It doesn't matter. And I had a case like that where my expert was right on the science. It was a shaken baby case, but she was just cold and scientific. And every question the defense posed at her, she's not. Like, what do you know? I'm the doctor here. I just came across bad. And the other expert didn't really have much science, but he was just a likable guy and talked plain English and didn't talk medical jargon, and he gave a plausible explanation that contradicted my expert, and that case went down in flames. Okay.
Kind of ground case.
That's what happens. So it's not just your credibility as a lawyer, but it can also be the credibility of those that you put forth. And not so much witnesses, your lay witnesses, but expert witnesses kind of have that same sort of dynamic working with them. So first thing, what are we gonna do? We're gonna look and act like an expert.
That's a good
Right? Go in there. I always go in there with that mentality. This is my job. This is what I do for a living. This is my home court. Some smart aleck potential juror is going to come in there and say, well, I don't think this is the law. I don't think that's the law. I'm not going to do that. Okay. And I'm the expert. I'm going to put him in his place politely and send him on his way, because he's never going to be on my jury. But you're supposed to, when you're in there, the juror looks for us to tell them what to do, right? What does this all mean? Well, let me tell you. And being the expert in our field matters. Right? If you didn't go in there and you're not confident and, right, you're looking to the judge, oh, can I do this, Your Honor? And that's not instilling any confidence in anybody. That's not leading them to believe that you know what the heck you're talking about. So when you step in there, right, this is your ball field. This is, you know, your arena. Act like it. Act like you're the expert that you are in this little courtroom. Because that's what lawyers are. Right? When you go to the hospital, you don't want a doctor coming in that doesn't know what the hell they're doing. So we need to portray that as well.
One of the things my friend Terry told me is another thing. I don't know where he was a collector of techniques, you know, or tidbits. And he said, one of the things you want to do very early on when you're talking to jurors is you say something like, I'm gonna move this lectern so that I can talk to you here in the jury box, but also so the rest of you can hear, because some of you might, you know, eventually be in the jury box. You actually move furniture in the courtroom with the idea that it's just what people are saying, you know, this is where I go to work, this is what we do, and I have full authority. When the judge will tell you, you know, you can enter the well, you say, well, let me just move this around, move this around. It's just, those are little things, but I can tell you that part of showing the jurors, the prospective jurors, that this is where you go to work, you do this all the time, and you know, you're essentially in charge, subject to the approval of the court, because you always got to remember, jurors will look at the judge as though they are basically infinitely qualified to manage a case. And you might have the dumbest judge, you know, that you've run into before, but that's the source of credibility in the courtroom, or at least it's the major focus of credibility. So just what people are saying right there, that part. You belong here, this is what you do for a living, this is where you spend your time. And, you know, when you really are comfortable with where you are, there's no problem taking it easy on the other people on the other side, and stipulations. There's no reason to bring a witness in to say something that could easily be said or stipulated to. And all those kinds of things show you know what you're doing. And that's back to credibility. And if you know what you're doing, the jurors are listening for what you think about what should happen at the end of this case. So that's all part of it. In a way, it's a little bit of play acting, I think. But I mean, that's what we're doing. We're putting on a show, you know. Only 12 people in the audience, and it only plays once. But well, sometimes twice or three times.
I demonstrate fairness and objectivity. Right? We've kind of talked about that. If they think that you're being fair, that you're giving the other side a fair shake, right? That's a small thing to call somebody by their name. Big thing in the eyes of the jury. This guy seems fair and objective. And, you know, I've been in a criminal trial. That guy wasn't. He just tried to demean the defendant at every turn. Keep your promises. First off, I never make promises, but people do. You know, they stand up there and they make promises to the jury, and if you do, you better keep them. You know, not just because there might be somebody on the other side that's going to point out all the promises you didn't keep. You know, the jury will pick up on that as well. I always take notes of opposing counsel's opening statement. And then when they don't deliver what they said, I shove it down the throat. Remember when counsel stood up and talked to you? What did he tell you? A, B, C, D, and E. Did any witness ever come in and say any of those things? Where is it? Where'd that come from? You know, if you make a promise, keep it.
You're right. Don't make any more promises than you have to, because you never, believe it or not, as prepared as you can be, always something comes up in cases that you didn't plan for, and you have to figure out how to not look like a hurt. I mean, you got to tell your client. This is another really important thing. You tell your client, don't pick up your pen and start writing furiously when something bad comes in, you know, and don't try and talk when we're listening to the witnesses. You got to give them a little training program, because as soon as somebody starts writing furiously, like, oh man, that was bad for them. You know, I mean, that's the impression that you get. So you got to be very careful about all that kind of stuff. And for sure, if you promise that you're going to do something, I do the same thing, but I'll tell you, in fact, Lisa DeMaria, one of our favorites, said to me, well, didn't you give your closing argument in your opening statement? And I said, yes, that's why I'm here. Yes, I didn't argue it for inferences and all that, but of course, what would you want me to say in my opening statement? Something I'm not gonna say at the end of the case? How simple is this? But yeah, because, you know, sometimes you put a little emphasis in your opening statement. You run close to the edge as far as argument, but yeah, gosh, you should be able to stand up and basically take the skeleton of your opening statement and make your argument. Because that's what you should be talking about is the opening statement, where you're gonna end up at the end of the case. And so then if you say certain things are gonna happen, you better know that they're gonna happen, or certain witnesses are gonna say what they're gonna say. The flip side of that is so important too, what Pete's saying, if they don't make their promises, it's a problem. If you do, you say, I told you this is what you were gonna see. This is exactly what you saw. And these people came in and said exactly what we told you. That's what this case is about. So you can turn it around. You can cash in on your promises as long as you don't go ahead and come and testify the way you want them to. Every once in a while, it doesn't work out like you expect, and then you have to make sure you don't flinch too much when you hear something you didn't want to hear.
Want to make concessions? Small thing that goes a long way.
Yep.
Right? You just gives that air that you're being fair, you're objective, you're not afraid. Avoid weak arguments. Why do you want to make a weak argument? You want to put your best case forward. Your strongest arguments, your strongest evidence. If you got a witness or a piece of evidence that doesn't move your case forward, why are you calling them? Why are you putting it into evidence? You should have your arguments that you're prepared to make, your best arguments, and develop your case around that.
And don't have too many.
When you have weak arguments, it looks like you're stretching, and you lose credibility there. Really? That's your argument? I'm not buying that. So you can't just stay away from it.
There's a correlate. If there are weak arguments that you could make, but it sort of depreciates the value of your good arguments, one of the things you want to do when you get to the advanced class, you want to set up certain things that are going to cause the jury to talk about it. And you don't have to say that this is an argument that you should consider. You just lay it out there for them to consider, because people latch onto things if you do it right. I mean, if you really encourage the jury, you're the ones that decide what the facts are. Like this, in this case, I have a 9mm shell casings and 40 caliber shell casings. And so there's a question about what happened and who shot first and all that. And there's potential for who shot first. I don't think it's much of a great argument, to be honest. So I just asked the cop who came in and authenticated these. I said, well, you really can't tell whether the 9mm were shot first or the 40 calibers, right? Or the 40 calibers were shot first or the 9mm, right? Or they were being shot at the same time. You can't really tell that from this evidence that you picked up, can you? That's it. I'm never mentioning that in my closing argument. I'm just throwing that out there because there might be some interesting person who says, well, you know, if you can't tell who did it first, then how do you know? So there's things like that that happen too. So the weak arguments you sort of leave to the jury to make on their own. You don't make the arguments. You just sort of set it up if somebody wanted to go in that direction. So you're not the one selling a bad argument, but there might be somebody in the back that finds it to be a good argument, and if they want to sell it, let them sell it. So what I said though, and I'm serious about this, if you have 3 major points in a case, that's about all you need. Never exceed 5. So you don't want to have just 2. So, you know, the numbers 3, 4, or 5 of your best pitches. Now, those can have subcategories, you know, when you get into complex litigation. But, you know, I made an opening statement in this case, and I said, there's a question of presence. I'm going to tell you right now, my guy was there, so you don't have to worry about struggling over this. There's a question of identification, and the identification is going to be questionable because of clothing and because of the nature of the weapon that my client was wielding at the time, because he was. But the the bullet that killed the guy is not from the shotgun that my guy had, then that's gonna be a question of intent. Why did he go to this party in the first place? And, you know, what was his intention when he was over at this other party, the two party where people get shot up? And that's it. So this is my case. Presence, which we concede he was there. What's his intention? And what was the second thing I just said?
Identification.
Was that?
Identification.
Yeah, identification and intention. And those are sort of interchangeable. Probably talk about identification first, but his intention going over to the party. Okay, so now everything flows from that, but it's simple to remember, because remember the jury, some of them do have every testimony, that piece of testimony read back, but they're getting impressions from witnesses. And some of them pick up detail, but most of them don't. And so it's impressions from witnesses, and it's impressions from both counsel, and it's impressions from the judge. And I even asked the judge, I do this all the time, I said, I want 12 copies of the jury instruction. I want every juror to have their own. And some judges say, what are you talking about? Why should they have to ask the foreman, could you read me instruction 603? Why can't they just have their own? And I have to say, from the defense point of view, I think it creates more chaos than it does order. But I'd like to have somebody read it and say, look at this right here. You know, they're making their own arguments. So this judge is going to do it in this trial I'm in now. Some judges don't. And you ask them and they say, no, I'm not going to do it. Well, okay. It's a trend, though, in the courts now to ask judges to give jury instructions, a packet, for every one of the people that will be deliberating. So don't forget that as well. It's a good thing to use. So what
Language.
Language.
Plain English, don't speak, don't try to speak over their head, don't try to impress them, don't use legal language, simple language. You know, get you where you need to be. Of course, we talked about avoiding the gimmicks and the tricks, and I actually had a trial one time where a defense attorney literally answered his phone while he was at the podium giving a closing argument. And played with it for a little bit, like, oh yeah, I'm here in front of the jury, and I'm okay. I say hi. Judge didn't take kindly to that.
Wow. So,
Right.
Is it a real call, or is it just a
I-
gimmick?
It rang. It rang. It wasn't on vibrate. It rang, and he answered it. I won that case. So, talk about keys. Right, imagery, importance of technology. I want to talk about just a little bit about just, there's some talk about imagery and you know how that plays a role, and you got to find out what image you're trying to project to the jury, right? Every attorney has something, you know, they're trying to project, and I had this one case against this guy who, you know, his nickname was Cowboy Bob, right? And he came in jeans and boots, and the court never told him anything. He had a little bolo tie, he had the coat with the fringe, and you know, and that was his stick, you know, and everything he did in his opening statement, he made all these cowboy references, and the westerns, and my horse parked outside, you know, just jokey stuff. And
Is that in Blythe?
it wasn't Blythe. He was from Imperial.
Bob Espinoza.
Bob Espinoza, yes.
Well,
Cowboy
I know his
Bob.
brother, and I know him. I used to refer,
You know?
he drives people crazy too.
That was his stick. Okay. I can tell you, like for me, there seems to be this theme amongst defense attorneys that they always want to project this air of massive resources and you know, technology for the government, you know, and they always talk about, well, the government. And I never like to have an investigating officer. I always like to just sit there on the other side all by myself. And I used to pull my beat up, broken down little cart taped up with, you know, duct tape and little old me. You know, you want to talk about the government, it's just me. And I was low tech, I was an Elmo, I was pictures, I never tried to wow them with anything. But I've seen attorneys who use technology, and it can be very impressive and very persuasive if done well. And so don't stay away from that, but just know what it is you're trying to project and what potential downfalls. Like, I was always scared to death if I tried to use any technology, it would freeze up, I wouldn't know how to fix it, and I would look like an idiot in front of the jury. So I stayed away from it.
And if you use technology, you always test it out when the jury's not in the room. You make sure it works every time, including if you're gonna have a session in the afternoon, you come back and make sure that it's still working. Because it's amazing, the stuff they have in the courtrooms now, we're doing this transition to sort of more expanded technology. And sometimes only the deputy now can figure out how to put stuff on the Elmo and all that stuff. It's crazy. But the worst thing to do is to fumble around for 15 minutes and then say, oh, I'll just do it without it. It just looks, again, your credibility is in the toilet. Manny Bustamante is probably one of the best on technology and does a great job. And I always, when I had several trials, and I have a couple of them coming up, I always try to contrast it and not use technology and use what he was saying, you know, pictures. I mean, I can put on a PowerPoint. I've done PowerPoints when I first started coming out for seminars for years. But, you know, can you give them another view of how to present the arguments and argue the arguments? And you should see the guys that, I guess they got help from somebody, and it's got all the things sliding in and the stuff coming up and things expanding and swipes and all that. And then in the middle of it, it breaks or something. And then they don't know what to do with it. And then if they haven't actually, you know, thought through their argument and they just go through, here's the elements, and then they lose it. It's amazing how the credibility just goes in the tank. So technology, I think it's important to have technology. I really do. And I think that especially for complex cases, it's good to have summaries and all kinds of stuff. But it's your responsibility. I actually, when I first came out here, I actually had a portable LCD projector and my own screen because these things wouldn't work sometimes. And I would actually say, Ronna, can I just have a minute? And I would go up, put up my own screen, bring in my own LCD projector, and make it work, because they were having trouble having the laptops work through the Elmos in the beginning. So, I mean, it's your deal. You know, if it doesn't work, that's your problem, not the IT guy from the office or whatever. So try real hard not to have that.
And look at your court, right? I mean, I never used to think about it that way, but if you're going to use technology, okay, look at your courtroom and look how it's laid out.
Yeah.
Over here in Indio, it's not laid out well, right? It's all at the side, and so I'm standing in front of the jury talking to them, and everybody's looking over there if they're looking at, you know, any sort of technology. Like, guys, I'm trying to connect with you. I want you to listen to me. I want you to pick up on my emotion and my passion at this particular point. And you're all over there reading what's on the screen instead of listening to what I have to say.
And you know that our courthouse is completely ass backwards to every other courthouse in Southern California. So when the witness is on the witness stand, they're across the room from the jury. Every other courthouse in America, the witness is right on the other side of the judge, as close to the jury as possible. And I guess they thought, well, I guess you can look at the witness and judge their credibility, but they're across the room. So there's hearing problems. There's issues about where the screen is going to go because you've got the witness over there. The witness has to be able to see the screen. I don't know if you notice some of our courtrooms, when the screen comes down, the entire one side of the audience is left out. I mean, I don't know who came up with that, but wow, not somebody who does trials. Weird and good stuff.
So I've covered the principles of persuasion, and
Let me mention too, because we've jumped over this, just so you know, you probably have heard this. There's two theories of how do you get people to remember stuff, and it's the recency and primacy theory. So the first thing people hear and the last thing they hear are the two things that are the most lasting, that are the most persuasive. So you definitely want to say something significant when you start out, And you definitely want to just not wander into the ending and then say, well, I guess that's it. You know, you have to have some kind of ending that makes an impact. Everything in between sometimes is remembered and sometimes it isn't. That's why I say 3 to 5 points, major points that can have subcategories. That's it. Something in the beginning that gets their attention, something in the end that wraps everything up, and maybe 3 points, 4 points, 5 points. For some reason, odd numbers do better than even numbers in the middle. So there's studies that actually show those are the most memorable things. First thing you hear and the last thing you hear. So that's just a small thing.
You've seen a lot of trials, right?
Yeah.
How bad are lawyers at finishing their closing arguments?
Yeah, I mean, it happens a lot.
They're just not good.
Right.
Like, they're going and they're going and they're done, just like, yeah, so vote not guilty.
Yeah.
And then they got like another point they want to make, and then they kind of throw it down.
Oh, one other thing.
And like, oh, that should be automatic.
Yeah.
Right? Here's my dismount.
Yeah, exactly.
Especially like for a
Exactly what it
prosecutor and
is.
for a defense attorney, like I want a guilty, you want a not guilty, you should have some way to get out of your argument. Okay, and they're just bad. I've rarely seen a good ending to an argument. They just kind of just fizzle.
That's
And
not
a lot. It really is a lost opportunity to end with a bang. So you know, definitely keep that in mind.
The other thing is, I mean, and this is related to that, I'm always watching the clock. Like today, I had this witness, the bad witness in my case, and they put him on, and that's the guy right there, that's the guy I saw. And so I know I've got a whole bunch of descriptions of people that have just absolutely opposite clothes of my guy. And I figure there's no way I'm going to start going into that now so they can have all weekend to figure it out. So I'm setting it all up by saying, what was the lighting? Oh, the lighting in the party and lighting in the street. Oh, the lighting in the street was fantastic. So you could see people's faces. You could see their clothing. Oh, yes, I can see all that. And so right at the end, I said, well, you know, you called my client by his name 3 times. You never knew him before this event that took place in May of 2014, did you? And you've never identified him before until a preliminary hearing a year after it, when you were told by law enforcement that he was the person who killed your brother. And he had a yellow jumpsuit on, and he was the only person in the courtroom with a yellow jumpsuit on. And you saw him there, and you learned his name from law enforcement, and so you used his name 3 times. You never knew his name until law enforcement told you. You never saw him until that day, and now that's why you're advertising, you're identifying him here. And then, of course, at least the mayor objected. And then we came back and said, oh, and the judge says, oh, well, that's the end of our day. You want to end, you see, when you end at the end of the day, or at the break in the morning, or at the break in the afternoon, if you're on doing something, you had better end with something that they will remember. And you want them to be thinking all weekend, oh man, he never identified the guy until a year later after he saw him at the prelim with the yellow jumpsuit on? Oh man, because that tends to sink in. That's just another thing that work experience. So I'm always watching, and I'm always trying to figure out, because this judge doesn't take exactly the same time for his breaks. I hate that when I'm doing my part, because I want to know if I get done at 1 minute to 4 and he's going to break at 4, we're done. There's not going to be any comeback. And that doesn't always work. Sometimes you don't try and get rid of a witness. But just remember, all of this is orchestrating how the jury hears what they hear. That's a good example, by the way, of the recency theory. So the last thing they hear when they go home is something that you want them to be thinking about or sinking in until you come back the next time. So it's all of this it's a collection of techniques. It's sort of like, when you learn how to play tennis. Does anybody play tennis? I used to play tennis when I was a kid at the beach. In the beginning, you're like, oh, this is my backhand. Oh, this is my forehand. And eventually it's like, you don't think about any of that stuff. It's just all part of what you do in the process. So deconstructing it for this class is very helpful to us too, because we remind ourselves of the things that work and the things that don't work. So I'm sure we'll be doing this stream of consciousness quite a bit.
The last thing that they talk about there is logic and coherence. If you're not making sense, if you're just rambling, you're not going to be making sense. If you're not making sense in your own mind, you're not going to be making sense to the jury. Okay? And give them something to follow, give them some logic, give them something that makes sense, and they'll follow it, right, if you give them that opportunity. I think we wanted to talk a little bit, because you guys don't do it. You won't do it in this class, but we want to talk a little bit about jury selection, just to kind of give you an overview of that. Huge lost opportunity, in my opinion, by most lawyers. I don't think most lawyers use it like they should. I absolutely, when I'm picking a jury, am picking it with my case in mind, with the arguments I want to make in my closing argument, with the arguments I'm anticipating the defense is going to make in theirs, and I'm setting all of that up in my jury selection. So it's, when I come back to it, remember, we talked about this in jury selection, guys.
Mhm.
You know, especially in rebuttal, right? Remember, that's exactly what the defense is trying to do. That's why that's not a defense in this case. We've already talked about it. And you don't do it in explicit terms. You do it in a roundabout way that they're coming to those conclusions themselves.
Right, that's a really important thing. When jurors arrive at the conclusion themselves, they're much more convinced that they just take your word for it. So if you can lead them down the path and then say, make a decision, especially if you've already built in some of the language from the jury instructions and all that, they're convinced they're right if they came up with a conclusion themselves.
That's a good point. Use the language as much as you can. You use it in your voir dire, you use it in your opening, you use it in your questioning, and then when the judge instructs them, you know, it's almost like they don't even make the connection that, oh, that's the law that the judge is giving them. They're like, oh, that's what he's been saying this whole time.
Yeah, it's back.
He knows what he's talking about. This guy's not using that language. He's trying to trick us. You know, so jury selection, I really think it is. People don't put time in it, and I think they miss that opportunity. It's a can be very powerful part of the trial, and setting the juror's mindset to receive your case, right? You get them thinking about the issues in a way that you want them thinking about it. And I always use extremes. I always use extreme examples to make my point, and I get them on board with that. And then when, you know, they're on board with this, and then they see that it's this issue is really just this, that's nothing. That's easy for them to
Make the leap.
You know, get rid of that.
Then there's two parts to jury selection. Obviously, the most important part is basically indoctrination. You want the jury to know the things that you're going to argue based on the fact that you started with your jury instructions, so you know what's going to come in this case. But then there's also deselection. People ask many times, like, what's the best juror? I don't know. I can tell you this. I know we got to get rid of the wingnuts and the weirdos and the people who said they would never vote or whatever. And so it's really deselection. I mean, we get so many we can kick off, and we can establish that someone, you know, says I'll never be fair or whatever. But I don't know, you know, it's taking a big bunch of people and getting it down to ones that you think you have at least a halfway decent chance of getting a fair hearing in the case. And sometimes you just don't know. I mean, you have people that, you know, my brother was murdered last year. Well, come on, you know, this guy's not going to be on this case. Even, I can be fair. No, I can put that out of my mind. Well, that person's not coming. Or, you know, I don't like people that use guns. Well, if you got a case where somebody's going to be shooting a gun, come on. So there's the indoctrination part, which is terrible. That's really what we're doing. We're telling them the arguments we want to make at the end. So I'm talking about the presumption of innocence and the standard of proof beyond a reasonable doubt. And the prosecution is talking about only one witness, testimony of one witness can prove any fact that's in dispute. And, you know, aiding and abetting or whatever. So, and it's in the context of, will you follow this law? Because if you won't follow the law, then we can't have you be a juror. So here's what the law is, will you follow it? And so he's making his pitch for the stuff that he's gonna make, and I'm making my pitch. But we're doing it subtly so that it's not just obvious. And of course, you're not allowed to talk about the facts of your case in jury selection. You can talk about categories of information, talk about expert witnesses, you could talk about weapons, you could talk about gang violence, but you can't talk about a specific set of facts that's part of your case. So you want to find out. I mean, I actually had witnesses or potential jurors tell me that they were scared to death of gangs, and I had one jury, we hadn't selected the jury yet, who asked to be escorted out from the courthouse down in Orange County in Santa Ana because we had used, there was a hint that gang stuff was going to come up, and they actually thought that they were going to be, having violence visited upon them because they were in a courtroom where potential gang stuff was going on. So, but I think Pete's absolutely right. You want to resonate the same arguments from the very beginning in jury selections, into your opening statement, into all your direct and cross-examination, all the way to your summation, your closing argument. If you're resonating the same stuff, you're bringing the people along with you. And so I think so many people blow it in jury selection. And some judges are just mean, and they give you 15 minutes or 20 minutes to pick a jury. When I first started, literally guys would take a week to pick a jury for a DUI. I mean, just go on and on and on. So I think that's part of whatever proposition it was. All of a sudden, no, you're not going to do that. So even in a murder case, you go more than an hour with your initial presentation, judges are starting to get a little antsy. I think we got a jury in this case in a day and a half, on a case with a murder and 5 attempted murders. I don't know, 2 groups of 85. Mm-hmm. And that was fairly long-winded according to most people's evaluation these days. So
a couple quick points on jury selection that I want to just end up on. If you're going to talk about something, know what the hell you're talking about, right? You don't want to ask a question, then have a juror, well, what do you mean by that? Well, it's a question that's in this voir dire book that I'm supposed to ask, and I don't really know why I'm asking it. I mean, you need to be comfortable enough in everything that you're asking the jury that if anybody challenges you on it, that gives you an opportunity to step up and demonstrate you're the expert, and you're going to kick that person off anyway. Anybody that ever challenged me, I knew I was going to get rid of them regardless, but I used them as my sounding board for everybody else. Everybody else listen while I explain it to this guy. And I never bring it up again, right? But they've heard what I've said to him. And another thing is have your voir dire for your case. Okay, I have things that I want to talk about, and in the criminal world, defense gets to go first. I never address what the defense talks about, rarely, unless they just completely misstated the law. I talk about what I want to talk about, and then I sit down, and if I've done a good job, the defense can't wait to get up there, and they're going to spend their whole second round of voir dire trying to tell a jury everything that I said that's wrong. Mm-hmm. And then I stand back up there and move along to something else. And from a perception standpoint, it's like, Mr. Noma really got under their skin. Mm-hmm. They really didn't like, but they had already heard everything I said, which seemed reasonable, logical, fair, objective. They hopefully maybe started liking me a little bit, and then when the defense got all agitated and came up and had to address every single point I made, well, you're pretty defensive. Well, why are you doing that? And so it's a little something that in my mind, I was like, I'm not going to address what they want to do. I want to leave that visual. They're worried about what I'm talking about. I couldn't care less about what they're talking about.
There's a corollary to that too. When you are doing cross-examination, I was saying before, you don't just repeat everything the other guy said. What do you want to get from this witness? What's the point of asking many questions? Most of the time, it's questions that weren't even addressed, or if they were, they weren't addressed in the way you'd like. and all you're gonna do is go in and get it and get out. And I don't mind. I mean, even in a serious case, if I ask 5 minutes worth of questions, if I got what I wanted from my argument and I'm happy with what I got, I'm done. So a lot of people think you have to rip someone to shreds in cross-examination. That's just baloney. That's TV. The best thing you can do is get somebody to be congenial with them, and they're giving you what you want. And you get it from them by being friendly with them and decent with them. And in your argument, you use what you got. You don't try and force them to give you what you want for the jury in your closing argument. You just get what you need in one question short of what you really need for your argument. It's amazing how much easier it goes. And if people think you're going to be nice to them, they're much more forthcoming. If they think you're going to be a tough guy, or if you are a tough guy with them, then all of a sudden it gets to be nasty. And then sometimes the jurors feel sorry for them. And that's really not where you want jurors to be. Because if they're feeling sorry for the witness, you are losing. So
I'm thinking next week, we'll talk about opening statements. We will pick the cases that you guys are going to use to give your opening statements. And we will begin the outlining of the process for forming your opening statements.
So no draft is due next week?
No, we will work together on putting together how you formulate. And it's going to be different based on the cases that we choose to work with. So I'm going to send out an email just to get a group email in place. What I would like each of you to do between now and next Thursday is take a look at the casebook, take a look at some of the types of cases that are there, and if you have a case in mind that you think you'd like to work on, send it to us, and those will be the ones that we use going forward. So choose wisely. The ones that are here seem to be the ones that everybody liked anyway. So you may pick State v. McNamara. It's a DV case, and Kent v. Bond Rental had a lot of issues. That was kind of good for both. And Price v. Jim, that was the
drywall thing, wasn't it?
Yeah. Oh, and we've got the Christian worker who likes to proselytize all of his co-workers. Yes. So I mean, there's some interesting ones in there. Pick the ones that you guys think you might be interested in. And you see, you don't have a reading assignment for next week. Your reading assignment is go through the casebook and try to identify a case and shoot that to us so we can then formulate who's going to do what and when.
And I apologize because I'm driving back from Riverside next Tuesday, and I might be a couple of minutes late, but I told the judge, and I've got a niece with me, so it's like, Judge, she's got to get to class. But I'm really trying to get me to class. I think by the time the third week comes around, when Pete's not going to be here, I'll be here. We'll have some guest speakers, and I shouldn't have any issues getting back from Riverside. But this is actually, to me, it takes getting everything else under your belt, almost everything else, before this class makes any sense. And this is now taking the next step from law school to what really goes on in the courts. And I know it's probably mental illness, but I still get a kick out of it. I just still do love going to court. And so I'm glad you guys are here. We'll tell you what we know, our tricks.
Yeah, and we absolutely hope that you guys get something out of this and that you enjoy doing it. I agree with Dean Nolan. I mean, I love being in a trial. It's one of the most it's one of the most exhilarating parts of being a lawyer, right? Getting up there and standing in front of this jury and giving your closing argument and trying to persuade them that you're right. That's what every case is about, right? You've been reading cases for 3 years, and being able to argue a side, it matters, but it's not for everybody, right? There are plenty of lawyers that work for trial firms that just aren't good at it, don't want to do it, don't care if they ever do it. They're just not, they don't like the public speaking aspect, they don't like the, potential to lose. If you never go to a trial, guess what? You never lose. Never lost a trial. How many you do? None. But, so there's that aspect of it. But seeing it all come together, seeing the case develop the way you planned it in your mind, this is how I'm going to present this. These witnesses, these exhibits, this is how I'm going to cross-examine these defense witnesses. And at the end, I'm going to stand up and be able to do this. And every once in a while, it comes together just how you planned it, and the jury comes back your way. It's a great feeling.
And you've been practicing doing this since the beginning. When you're writing a legal essay, all you're doing is identifying the issues, organizing the issues, and making arguments for the issues one way or the other. So that's part of what legal essays are all about. Eventually, that evolves into some guy coming to your office and tells you the big long story. And then after you get all that and you get all the documents, you have to take the story and figure out how to work it into something that can help that person to prevail. And then you're basically organizing your arguments. So you're identifying issues and organizing arguments. That's what we do. And this is the ultimate, when you actually identify the issues, organize the arguments, and present it to somebody to see if you were persuasive enough to get them to see it your way. That's what we do. This is fun stuff.
Yeah, it feels good when they, especially afterwards, when they come out and they tell you, good job.
Yeah. Your client was guilty, but can I have your card? Yes, thank you very much.
So that's it for tonight.
Thank you, guys. So, also gives you an opportunity to work on the other classes.
But don't forget about this class.
No. So I'm gonna see if my little helper just go there. I think they're gonna shut it.
You guys are probably thinking, you really just want to talk about this, don't you? It's a fun topic, and it's really neat when you learn new little tricks and you see somebody else do something. I'm gonna work that way.
I'm really excited about this class. I mean, I am convinced that this is going to be my biggest part of my, ability as a lawyer. So I want to
Learn how you like to talk.
I like to talk, but I started my whole life and was in speech therapy until like late high school. So
Me too.
to me, it's just not. I'm not comfortable with it. It's not natural.
You can become more comfortable. All right, Victor. Good to see you.